Ladies and gentlemen, the next segment, again, Chris gets to play. He's not a bad actor, he's pretty good. Tries to stay pretty neutral. The next section is the direct examination of Hoover as the adverse witness. And so to do the direct examination, which is truly a cross-examination, is my partner, Ben Rubinowitz. Ben is known probably to most, if not everyone in the room. He has been one of the most, if not the most successful trial lawyer in the state of New York for many years. And Ben is a professor at Hofstra and Cardozo and travels all across the country for NIDA, teaching trial skills. He could teach us about trial skills all day, every day, and you will continue to learn. He authors a column in the New York Law Journal, and he, along with one of our summation speakers who's in the back of the room, Evan Torgan, are both a member of probably the most prestigious plaintiffs organization in the United States, and they're two of the youngest members of the inner circle. In any event, the best compliment I can give to Ben is that I always tell my wife, if I'm ever hit by that bus or truck, and she's got to hire somebody to represent me, try my case, it would be Ben. And he's extremely worthy, and I think one of the scariest defense attorneys around is Richard Mackauf. Why is he one of the scariest defense attorneys around? Because I'm not sure if Dick ever loses, and he goes into some of the toughest county with heavy-duty product liability cases that chop people's various body parts off, and he goes in front of some very liberal judges, and he goes into some very, very difficult places. And Dick is as prepared, if not more prepared, than any other lawyer you'll ever meet. He's disarming with his charm and his personality, and at the same time goes right for the throat. You guys are about to see a great presentation, so without anything further, I turn it over to Ben.
Thank you, Howard. Stay away from buses. Good afternoon, everyone.
Ben, is your mic on?
Can you hear me in the back? Yes?
Yes.
Okay, turn it on. Hopefully it's on. Okay. Let me tell you what I'd like to do this afternoon. I'd like to speak with you first about the adverse direct examination of a witness, whether it's an expert witness, a site safety foreman, or anyone else. And then I'm going to do a demonstration of an adverse direct examination. And there are reasons we'd want to do an adverse direct examination like this. If we as plaintiffs' lawyers are setting up our case, one of the easiest ways for us to present our case is to know exactly what the opposing witnesses have to say first. And if you're confident in your cross-examination skills, adverse direct examination skills, really the same thing, what you can do is you can lay out your case in advance of the time that you call your own expert, so that your expert knows exactly what it is that the other side has had to say, and then you can proceed in that regard. If you wait and choose, for example, not to call a witness like this, but allow the other side, my adversary, to put this witness on first, and our expert has already testified, what happens if our expert has some of the facts wrong? Or what happens if there are certain facts that don't necessarily coincide with what it is that we're saying really did take place? Well, that's a very dangerous thing for us. So what we want to do is we want to lay out the case in advance, and we want to lay it out in such a way that the witness starts to agree with us when we start speaking, when we start doing this adverse direct examination. So we found, and Evan and I have written about this, we found one of the easiest ways to do this is to use certain techniques in cross-examining adverse direct. It's one and the same. A witness like this, and I'm going to show you how you can do it. Because as far as I'm concerned, and I know Evan feels the same way, there are two schools of thought for cross-examination. One school is the baseball bat approach to cross-examination, and the other school is the voice of reason approach to cross-examination. And you've all heard the baseball bat approach, you just haven't heard it called that. But the baseball bat approach to cross-examination is where you stand up, you look at the witness, you're ready to swing. Basically, this is it. You're full of shit, aren't you? Well, if you do that, if you start off trying to hurt the witness right away, the witness is going to resist the questioning that you have. The voice of reason questioning is on the other side of the spectrum, where what you're doing is you stand up and you ask questions that are so ultimately reasonable that if the witness dares to disagree with you, that witness looks like a horse's ass, and no witness wants to look like a horse's ass. So they'll start to agree with you. My suggestion is, if you can, start off with sugar rather than sting every time. The sting or the vinegar isn't going to help. But if you start it off nice and easy, you can get a lot more mileage with this. So let me go right into the cross-examination of the site safety expert. Good afternoon, sir.
Good afternoon.
Is it true that you are the foreman of this job?
Yes, it is.
And in fact, you worked on the very day of this accident,
I did.
back in September of 2010?
Yes.
Your title at the time was the site safety foreman, correct?
Correct.
And one of the things that you've been doing is you've been a foreman in this job for many years, correct?
Yes.
Tell the court and jury how many years you've been a site safety foreman.
About 20 years.
During that 20-year period, would it be correct to say that you have trained younger, less experienced workers, both male and female, to be site safety foremen?
Yes.
When you train these younger, less experienced workers to be site safety foremen, one of the things that you stress to them is the importance of doing a full evaluation of the site, correct?
Yes.
Certainly one that's fair, am I right?
Yes.
Certainly one that's complete?
Yes.
Thorough is your motto, true?
Yes.
All right. In other words, the failure to be complete in doing an inspection is something you would teach them never do.
That's true.
In fact, one of the things that you would never ever do is take shortcuts, correct?
I would not.
Because the goal that you have in mind is to prevent an accident before it ever takes place, right?
Yes.
And knowing that you want to prevent the accident before it takes place, you take the time to teach the other, less experienced foremen, when you're teaching them, familiarize yourself with the codes, correct?
Yes.
Familiarize yourself with the labor law, true?
True.
Familiarize yourself with the state regulations, true?
Yes.
And the federal regulations, correct?
Yes.
And certainly you've taken the time to practice what you preach, am I right?
Yes.
So you've also familiarized yourself with, for example, the federal codes as it relates to safety, true?
Yes.
Certainly you've heard of OSHA, am I right?
Absolutely.
Tell the court and jury what OSHA is.
OSHA is a set of federal codes designed to govern workplace safety.
And in fact, what you do is you actually explain to them in detail what they must look for when conducting site safety examinations and inspections, true?
Yes.
In the event that one of your students, one of your trainees decided to say, I'm not going to do a complete evaluation of this site, would it be fair to say that you would correct them?
I would.
Would it be fair to say that you would never, ever tolerate that?
I would not.
And the reason you wouldn't tolerate that is because it would be wholly and completely improper, true?
Yeah, I would.
In fact, you'd agree with this, wouldn't you? That it would be a departure from every single safety standard you'd ever learned if they didn't take the time to do a fair and full and complete inspection, true?
I would agree with that, yes.
Now, to do these inspections, would you agree with this? You have to evaluate the site.
Yes.
So when you teach the students, you tell them, if we know that a job is going to take place after hours, you tell them, take a look at the site, don't you?
I don't know if I've had that situation before.
So, in other words, if you know that they're working, for example, 9 to 5, you tell them, do the inspection, correct?
Yes.
But if they're working 9 to 6, are you really telling us the hour between 5 and 6 is somehow different?
No, that's not what I was saying.
Of course. So what you're really saying is, no matter where the inspection's supposed to take place, you do it thoroughly, right?
That's right.
And anything less would be a departure, true?
I would agree.
Sir, in this particular case, you know that an accident took place, true?
I did.
In fact, you heard my esteemed adversary, Mr. Fabiani, just cross-examine the plaintiff, true?
Sure.
And in fact, one of the things that you know is that the accident took place involving ladders, correct?
Yes.
One of the things that you teach those younger, less experienced foremen is the rules, the regulations concerning ladders, true?
Yes.
And ladder safety, am I right?
Yes.
Do you teach those students that it's okay to ignore the way a ladder is set up?
No, of course not.
In fact, in every given site that you have to inspect, you'd agree with me it would be completely, wholly improper to fail to inspect the ladders, true? Your time.
I don't know if I would agree with that.
So in other words, would this be fair? You want to make sure that no harm comes to the workers. Fair enough?
As best I can, yes.
Do you agree with the saying, an ounce of prevention is worth a pound of cure?
Of course, yes.
You live with that, don't you?
I sure did.
And you teach them that, don't you?
Absolutely.
And knowing that, in the event that a site safety inspection of a particular area that you know is going to be worked on is not inspected, that's something that you would have a problem with, wouldn't you?
Yes, I would have a problem.
And the reason you'd have a problem with it is because it would be a departure from safety standards, true?
Yes, it should be.
Sir, you know that involving this particular accident, a ladder was going to be used, correct?
I did, yes.
In fact, one of the things that we learned from the opening statements that we heard both Mr. Hirschhorns do, we learned that in fact there was a meeting before the day of the accident, correct?
Yes, I met with Larry for the accident, yes.
You met with the plaintiff and yourself, correct?
Yes.
Would it be fair to say that that meeting was about 5 minutes?
5 or 10 minutes, yes.
Whether it's 5 or 10 minutes, the bottom line is this. That meeting had nothing whatsoever to do with safety of ladders, true?
Yeah, that's true.
In fact, what that meeting had everything to do with was the cost of the project, right?
Yes, and the work to be done.
Well, obviously there are competing interests whenever you have a job to be done, true?
I'm not sure what you mean by
Well, for example, the speed at which the job is going to be done is one of the interests
that. Of course.
as a foreman, true?
Absolutely.
And the safety of the workers is another one of the interests, true?
Of course.
So now you understand what I mean by competing interests, right?
Yes.
And although there are competing interests, the one thing that we know at all times, safety wins, right?
Yes, it does.
If it was the other way around, you'd consider that a gross departure from any safety standard, true?
That's not how you would decide.
You'd consider it a gross departure, right? Tell them.
I don't know if I would use your words, but I would consider it not the way to do this.
Are you suggesting that it's a mini departure?
I don't know what you mean by gross departure.
How about a big one?
A big one, fine, I'll agree with that.
Okay. Knowing that it's a big one, certainly, even on this job site, you take the time to do the inspection, right?
Yes.
So let's go to the very day of the accident now, right to September 1st, 2010. On that day, you knew where the site was, right?
Yes.
Unlike what you heard in the opening from the second Mr. Hirschhorn, we never, ever spoke about where the ladders would be set before we came to this day, true?
No, we can't.
And unlike what you heard from that opening statement, we never, ever heard where the ladder would be placed prior to the day of the accident, true? Sir, what time did you leave the work site?
At 4 o'clock.
You knew when you left the work site that work was going to be continuing, true?
Yes.
You knew, correct me if I'm wrong, that the plaintiff was going to be power washing a facade of a building, true?
I knew that house.
A two-story building, correct?
That's correct.
When you knew that, would you agree with me that you knew that an inspection had not yet taken place of the area where the plaintiff was going to be working?
No, I don't know if I would agree with that.
So did you go to the site after you left the site at 4 o'clock?
No.
Did you make provisions for another inspector to come in after that?
No, I walked past that side a million times during the construction.
Sir, you knew a ladder was going to be used, correct?
I assumed the ladder was going to be left up to Mr. Crowe.
Let's use the words that you just used. You said, I assumed, correct?
Right.
So I want to focus on those rules and regulations that we spoke about before. Can you tell us one single rule and regulation that says it's appropriate to assume when you do a safety inspection?
No, I actually won't do
Can you tell us one thing in the OSHA regulations that says, let's assume, your word?
that. No,
In fact, it would be completely and utterly preposterous to assume what's at a work site without inspecting, right?
yeah, how would you decide?
So tell us, sir, you know the accident happened around 6:30 to 7 in the evening. Where were you?
I was at home.
Were you doing your dishes?
No, I wasn't.
I see you heard Mr. Fabiani ask about dishes. Tell the court and jury. Tell them, what were you doing at 6:30 to 7?
I think I was finishing dinner and watching TV.
So watching TV is the proper way to conduct an inspection of this work site?
Of course.
In fact, would you ever teach one of your trainees or students do the work site from home while you're watching TV or eating dinner?
No.
That would be absurd, wouldn't it?
Yes.
Sir, on this particular day, did you ever once call the plaintiff to find out what he was doing?
No, he wanted to be there.
Did you ask him how he was setting up the ladder?
No, I trusted him that he knew how to do it.
Did you assign anyone else to inspect the work site?
No,
Tell me something. Did anyone prevent you from going to the work site?
no,
You chose to do that on your own.
that was my decision.
Tell us what time it was that you made the decision, I'm not coming to the work site.
Larry does need to.
Tell us what time it was is my question.
4 o'clock.
And at 4 o'clock, did you even give it a second thought?
No,
Because what you wanted to do was assume, right?
no, I just trusted Larry.
In other words, you're suggesting, if I have you right, you're suggesting that the experience of the worker dictates whether or not you'll do an inspection. Is that it?
With someone like Larry, yes.
Okay, so what I now want you to do is to tell the jury, where in the labor law does it say, if I've got an experienced worker, I don't have to do an inspection? Where does it say it?
I don't think it said that.
It's not that you don't think it says it. You know it doesn't say it, right?
Yes.
In fact, if it said something like that, withdrawn, if one of your students or trainees said something like that to you, you'd say, that's no way to conduct an inspection, right?
That's true.
In fact, that would be completely inappropriate, wouldn't it?
Yeah, I'm not understanding.
To guess whether or not an inspection is going to take place.
You should not guess this.
Because if you do that, you can ensure one thing. No inspection will ever take place, right?
Of course.
And that's exactly the way you wouldn't want to do it, right?
I would, under certain circumstances, yes.
That's exactly what you did on this day, true?
I trusted Larry.
In other words, I trust Larry, I don't have to do my job. That's your motto?
No, it's not my motto.
That's what you did.
I thought he was set up properly, yes.
So when you do inspections as a site safety foreman, let's go back to this. I've got an experienced worker. No matter what's done there, I can blame the worker. That's what you say, right?
No, it's not what it says.
But that's exactly what you're trying to do, isn't it?
Well, that's what Larry
That's what you're trying to do, isn't it?
I'm not trying to do anything.
Let me ask you this. Are you trying to blame the worker because you didn't inspect?
No, I'm trying to learn the work because he said, well,
Excuse me. Are you trying to blame the worker because you didn't take the time to inspect?
No.
Was it too much trouble on that day, sir? Excuse me, just a moment. Was it too much trouble to inspect?
No.
That was your choice, correct?
Yes.
And only your choice, right?
That was my decision.